Good morning. My name is Matt Kairos, and I serve as Montana State University's Dean of Students. It's my pleasure to welcome you here to campus today. President Cruzado was scheduled to give these opening remarks, and unfortunately, she cannot be here today because of a medical issue. But she sends her regards, and she's glad you're all here. Now, I'll tell you, when your boss calls 15 minutes before she introduces the Supreme Court, your job is to say yes. And to all the students who are out there today, I want to let you know in your future profession, whenever your boss calls and asks you to pinch hit, do your best, say yes, and then, of course, do a really good job. I'm going to do my best to do that now. So, of course, welcome to your university, Montana State, and to this very special event. I wish to thank our hosts of this event who have worked so hard to bring MSU Law Day to life. MSU's Department of Political Science, MSU's Pre-Law Club, the State Bar of Montana, the Gallatin County Bar Association, and the 18th Judicial District Court. I also want to thank all of you who've chosen to be here today. Welcome to our faculty, our staff, and all MSU students. I also want to give a very warm welcome to our legal community, all the lawyers who happen to join us today. Also in the audience, we are represented from middle schools and high schools from the Gallatin Valley, and we want to make sure that you know we are very excited that you're here, and we hope you continue your education and consider Montana State University in your future. Last but not least, we'd like to welcome Chief Justice Corey Swanson and all of the justices of the Montana Supreme Court. It is a deep honor to host the court here on campus, and thank you for bringing your important work to Montana State University and our campus today. MSU Law Day is a rare and exciting opportunity for the public to see the highest court in Montana in action. It celebrates the rule of law. Think about that for a moment. Law Day is a recognition of the importance of law in our democracy. It provides a window to the crucial part of our system of government that many people do not have an opportunity to see in their daily lives. We are so proud to host this event and to host the court. I invite all of you to sit back and enjoy the next hour as we see our state's highest court in action on our campus. It's also my honor, the state of Montana, we're very proud of Montana State University. We're also very proud of the state's law school. And it's my honor to introduce to you the Dean of the state's law school, Dean Gagliardi.
Good morning. It is indeed a privilege to serve as Dean of Montana's Law School. And I say that, Montana's Law School, because we are the law school for Montana State University and University of Montana. It is the Alexander Blewett III School of Law, and it's actually named after a graduate of Montana State University and a graduate of Montana's Law School. I hope you will all indulge me for a moment. When I see so many future lawyers out there, I can't help myself but say a few words about our law school. And all of our alums, I know you'll want to hear an update as well. So Montana is a law school that trains lawyers for the people-oriented practice of law. We focus on skills training. And that has stood us in good stead. This year, I was really excited to find out that the Blewett School of Law is first among our peer schools from the Dakotas all the way to Oregon and all the way down to Colorado. Our peer schools in what I call the Rocky Mountain West, but I know the range is a little wider than that. We are first among all those schools for overall bar passage rate and job placement rate, 97%. Princeton Review this year ranked us as a top 10 school nationally in the entire nation for prestigious state law clerkships. Many of our students clerk for the Montana Supreme Court and for other Supreme Courts. The law school is also first among its peer schools for equally prestigious federal clerkship placements. It's a good place to come to school. I have to say I'm proud today to be able to also thank the Supreme Court for including us as part of Law Day. All but one of our Montana Supreme Court justices are graduates of our Montana Law School. Two of them were our classmates. And the one justice who is not a graduate of ours, her children are. They made good decisions. I want to focus a bit about being a lawyer. It has been an honor to serve as a lawyer and represent Montanans in resolving legal needs. It's a job where you find satisfaction every day in helping others and making change. And I want to thank all of you for being present today to observe our legal system at work. My remarks are going to be very brief, but I want to focus on the role and purpose served by lawyers and the judiciary. The Montana Supreme Court is one of the three branches of state government. And in Montana, we are different than many other states in that all three branches of government are elected by the people of Montana. The legislature, meeting right now and passing laws with the approval of the governor, who enacts the law, they act to represent the majority of Montanans. The purpose of the Montana Supreme Court and our judiciary is to protect not the will of the majority, but to protect the constitutional rights of each individual person and to provide a forum where persons can resolve disputes in a civil manner and with due process of law. Lawyers have the privilege and honor of helping individuals to assert their rights and arrive at a peaceable solution. And that is what you're going to see today as you hear the arguments. The justices of the Montana Supreme Court likewise ensure that individual rights granted under the law and our Constitution are protected. It is for this reason that the independence of our judiciary is important. The court system is the cornerstone of our democracy. So with that, I now invite Mr. John Moorhead, a second-year law student and member of our Montana Law Review, to introduce the case before the Montana Supreme Court today. Mr. Moorhead will explain the procedural posture of the case and provide an overview of today's arguments. So please join me in welcoming Mr. John Moorhead.
Thank you, Dean Gagliardi. Good morning. Welcome, everyone. My name is John Moorhead, and I'm a second-year law student at the University of Montana's Alexander Blewett III School of Law. On behalf of the Montana Law Review, I would like to thank the Montana Supreme Court for traveling to Bozeman today to hold this oral argument and for offering the opportunity to introduce the case to you all. We are here today to listen to the oral argument in Mullee v. Winter Sports Incorporated. The case is about a dispute between a skier in Whitefish Mountain following an injury the skier sustained at the resort. Let's start with the facts of the case. On January 16, 2019, Mr. Mullee was skiing at Whitefish Mountain. Mr. Mullee is an advanced skier who has visited Whitefish Mountain many times before. On that day, Mr. Mullee realized he forgot his cell phone and water bottle in his car. So he skied down a beginner trail to retrieve them, but caught an edge, spun off the trail, and fell into a rocky creek, breaking his pelvis. He was later medevaced to Seattle. Whitefish Mountain usually maintained a fabric fence at the edge of the trail. The parties disagree about whether the fencing was there when Mr. Mullee fell into the creek and the fence's purpose. Was it to warn skiers about the creek or to prevent Mr. Mullee's injuries? After the accident, Mr. Mullee sued Winter Sports for his injuries. Whitefish Mountain is owned by Winter Sports, the party in the case today. Winter Sports asked for the court for a summary judgment. A summary judgment ends a civil case before going to trial. In other words, when a party asks for summary judgment, the party argues that the facts of the case are undisputed and they should win as a matter of law. The district court agreed and granted summary judgment to Winter Sports. The district court concluded Mr. Mullee's injuries were because he was participating in the inherently dangerous activity of skiing. Mr. Mullee appealed. He argued that the district court should have concluded that Winter Sports should have maintained the fence to prevent his injuries because Winter Sports knew that the drop-off posed a heightened risk on a beginner trail. This leads me to the law of the case today. Messed up my pages. Mr. Mullee brought a negligence claim against Winter Sports. Negligence means failing to take proper care. In the law, we refer to that care as a duty. In the context of skiing, which is inherently dangerous, there is a law that balances the duty of skiers to protect themselves and the duty of the ski resort to protect the skier. The law is designed to promote the ski tourism industry in Montana, and that law is called the Montana Skier Responsibility Act. Typically, businesses have a duty to protect their customers from reasonably foreseeable harm. For example, if someone slips and falls on a banana peel in a grocery store, that grocery store has a duty to reasonably prevent the foreseeable harm of someone slipping and falling on a banana peel. However, the Montana Skier Responsibility Act shifts more responsibility from businesses, and in this case, ski resorts, to the skier. For example, while the Montana Skier Responsibility Act requires a ski resort to mark all snowmaking equipment on ski trails and post trail maps, a skier must read the trail maps, know their skiing abilities, and stay in control while skiing. Skiers are generally responsible to avoid injury when skiing because skiing is an inherently dangerous activity. So, unlike the banana peel in the grocery store example, if a skier falls while skiing at a ski resort, the ski resort is generally not obligated to prevent the fall. For Mr. Mullee to win on his negligence claim under the Montana Skier Responsibility Act, he must prove the ski resort owed him a legal duty, the ski resort failed to meet that duty, and because of that failure, the ski resort caused his accident and injuries. The crux of this case is whether Winter Sports owed Mr. Mullee a legal duty to prevent his injuries. Winter Sports argued that it did not have a duty to put up any kind of fence. The district court agreed. If the Supreme Court also agrees, the case is over. However, if the Supreme Court disagrees and finds Winter Sports owed a duty to Mr. Mullee, a jury may need to decide the issue about the purpose of the fence. On this main issue, Mr. Mullee may argue that Winter Sports had a duty to maintain the fence at the drop-off to prevent his fall. He may discuss other Montana Supreme Court cases and raise out-of-state cases to support his position. Winter Sports may respond differentiating the present case from previous ski-related negligence cases in Montana. Winter Sports may argue that it did not have a duty to prevent Mr. Mullee's fall with fencing. Winter Sports may justify its reasoning by pointing to the responsibilities of skiers in the Act and argue that the Act and Montana's legal authorities should guide the court's analysis today. This main issue is pivotal because if the Montana Supreme Court reverses the district court's decision about duty, Mr. Mullee has raised three other issues that the parties may address. Only if the Supreme Court decides Winter Sports owed Mr. Mullee a duty would these issues become important. In addition to the main issue, Mr. Mullee asked the district court to determine that he had a specific amount of damages because of his injuries. The district court refused to do so. Mr. Mullee may argue the district court made the wrong decision. Specifically, Mr. Mullee may argue that Winter Sports did not produce any evidence to dispute his damages from his injuries. Winter Sports may respond by arguing they did not need to produce evidence because there was a technical problem with Mr. Mullee's evidence to prove his injuries when he submitted them. The third and fourth issues are about who would be able to testify if there was a trial. In cases like this, parties often hire experts to talk about injuries and how an accident happened. The district court ruled that Mr. Mullee's doctors could not testify about his injuries. However, the district court ruled Winter Sports could have their expert present testimony at trial about how the accident occurred. The district court's rulings were based on technical procedural rules and fairness to the parties. Mr. Mullee may argue that the district court made incorrect decisions about these issues. These issues would matter if the case goes back to the district court for trial, which leads us to today. We are here for an oral argument before the Montana Supreme Court. Unlike a trial where there's a jury and lawyers submit evidence, an oral argument is more like a conversation between the lawyers and the justices of the court. The lawyers have already submitted their legal arguments in writing, and now it is the justices' opportunity to ask the lawyers questions about those legal arguments. The Montana Supreme Court is the highest court in Montana. That means that this court's decision will be the final say. An appellate court reviews a district court's decision. In an appeal like here today, the parties are called the appellant and the appellee. The appellant is the party that lost at the district court and is bringing the appeal. The appellee is the party that won at the district court and is opposing the appeal. Mr. Mullee is the appellant, Winter Sports is the appellee. In an oral argument, each party is granted a set amount of time to argue their case. You will first hear from the attorneys for Mr. Mullee, and then the attorneys for Winter Sports. After the oral argument, the courts take the arguments under advisement. The justices will deliberate and discuss the issues in the coming weeks and months, and then issue a final decision. That is the introduction. Again, I would like to thank the Montana Supreme Court for the opportunity to present this case to you all on behalf of the Montana Law Review, and thank you all for coming today. Rise and give your attention to the Honorable Justices of the Montana.
Please be seated, everybody. This is the time set for oral argument in DA 24-0356, Mark Mullee versus Winter Sports Incorporated, doing business as Whitefish Mountain Resort. Before we begin, we've got some echo in here. I want to briefly introduce the members of the court. My name is Corey Swanson. Starting from my left, your right, Justice Jim Rice, Justice Jeremiah Shea, Justice Lori McKinnon. On my right, Justice Ingrid Gustafson, Justice Beth Baker, and Justice Catherine Bidigary. I want to briefly invite counsel to introduce yourselves before we begin the argument, beginning with the appellant.
My name is Ian Gillespie. I represent the appellant, Mark Mullee.
Your Honor, Michael Moore, here on behalf of Winter Sports Incorporated, Whitefish Mountain Resort.
Chris DiLorenzo on behalf of the Appellee, Winter Sports, Inc.
Welcome. And then just let me know if you want to divide your time in your arguments.
Yes, Your Honor.
Okay, so just let me know allocation of how you want to do that.
I'm anticipating 30-10.
Okay, just so everyone's aware, so the appellant is allocated 40 minutes total time for argument. He has a initial argument and then he has a rebuttal. So he's going to reserve, it sounds like he's tentatively planning on 10 minutes for rebuttal. Sometimes our questions take that plan off track. Okay, we are ready to begin.
May it please the court, and good morning. As stated, my name is Ian Gillespie. I represent the appellant, Mr. Mark Mullee. Mr. Mullee was the plaintiff in the lower court proceeding. We are here today to address 4 issues, although I defer to the court how much attention the court wants to spend on each issue. The first is the summary judgment order that the district court granted in favor of the appellee, Winter Sports, Inc. It's commonly referred to WSI, which is a ski resort that operates colloquially known as Big Mountain up near Kalispell, or also known as Whitefish Mountain Resort. The second is a summary judgment order that denied Mr. Mullee's motion for summary judgment on the issue of damages and the nature of his injuries. Essentially, the court denied it. We contend that it's effectively undisputed, the nature of certain economic damages on his behalf, on his part, and also the nature of his injuries, which most importantly is a severe pelvic fracture where he had to be life-flighted to Seattle after the fall. The other set of motions are motions in limine on the parties' respective experts. One is an order from the district court precluding Mr. Mullee's medical expert, Dr. Donaldson, and then the following experts of a life care planner and an economist to testify about his economic damages. And then Mr. Mullee had actually filed a motion in limine on defendants' biomechanical expert, Dr. Irving Shear. And I can get into more detail, I think, when we address each issue. But I'll start, if the court is okay, with the summary judgment motion dismissing my client's case. Summary judgment is de novo review, right? Summary judgment, as the court has held, is an extreme remedy, or actually the Meade case, which is the most recent Montana Supreme Court case, although it's been a couple decades, is that it's in exceptional circumstances that the court will grant summary judgment motions, including in ski cases, right? The court is probably well aware that the Skier Responsibility Act has been passed by the Montana legislature, but the court has addressed this in prior cases, Brewer and Meade namely, about what that act means in reality when interpreting a negligence claim like Mr. Mullee's when he's injured skiing. Now, what the Montana Supreme Court has held and what defendant does not dispute is that the defendant, or WSI, is still held to the duty of reasonable care under the act. Otherwise, the act will have constitutional infirmities under Brewer and Meade. And that is undisputed. That's not an issue raised by the defendant in the appeal, is overturning those prior cases. So what the district court had relied on is essentially, or analyzes the issue of duty, right? And we contend that WSI did have a duty and breached a duty here, or at least there's a factual dispute about the reasonable care here. There's two arguments, essentially, that the court has to address and that there is a record of. One is whether or not the fence was up at the time that Mr. Mullee actually arrived on the scene. Okay, he testified that essentially the fence was down at the time that he arrived. I apologize. And he's the only person to witness this fall, right? WSI ski patrollers are supposed to check the fence every morning, right? And they don't dispute there is a fence. They had the practice of maintaining what's called sea netting or a snow fence colloquially in that location. So they are actually assuming the duty of placing a fence there, right? But the ski patroller.
Mr. Gillespie, can I interrupt you for a minute?
Yes, Your Honor.
So can you define the duty of reasonable care that you're asking us to hold? I mean, because some of what you're talking about is really addressing a breach of that duty. Could you define what the duty is?
So again, there's two arguments here under fact. So in this first argument, which I was getting into, was that WSI had let the fence fall that morning, right? And so they had not checked the fence that morning. There's evidence that it was knocked over by a snow groomer. That's what it appeared to my client. There was actually a fence covered in snow, if you look at the photos that actually I put in my brief. And so they had the practice of checking the fence every morning because it is a safety issue. They testified that, you know, there was a hazard there, right? And so the fence was actually down when he arrived, and they didn't provide reasonable care to keep that erected to warn skiers or prevent them from falling down the steep embankment, which is what he fell down, and actually suffered the serious injury he did, right? And consistent with that, Mr. Mullee testified, only person to witness, the fence was down, okay?
So your belief is that the Whitefish Mountain admits or concedes that they had a duty to put the fence there, that once they put it up, they had a duty to maintain it because, and you think they concede that?
Now, I don't believe they conceded in their briefs, you know, filed by their lawyers, but what their practice was undisputedly was to maintain a fence there and to check it every morning per the ski patrol manual, okay? And they don't dispute, at least their employees don't dispute, that the ski patroller is supposed to go down there every morning and check the fence.
So what requires them to actually put in the fence, though? I mean, there has to be some reasonable foreseeability, right, or foreseeability, and your briefs say that they knew there was a heightened danger on the beginner trail. Is that where they get the foreseeability?
Yes, Your Honor.
And what was it that put them on notice, that they knew?
Well, they knew that there was a drop-off, right? They actually maintained a fence there, which speaks to knowing that there's at least a danger there. That's the purpose of the fence. They dispute sort of the nature of why they put the fence up. They say it's just to warn skiers, but nonetheless, that proves
Well, we
or
don't
shows.
have fences on every drop-off, right? I mean, I have a little bit of experience with skiing, and so, you know, there's several drop-offs all over mountains, all over the country that don't put up any fences, and if they put up a small rope, is that, you know, then are they on the hook for it? Or like, how do they know where they have to put the ropes and where they have to put a snow fence and where they have to put 2 snow fences and where they have to put padding? And if we go with your theory, how does that inform ski areas of what they have to do when there are a myriad of hazards, trees, stumps, gullies, creeks, all over ski mountains everywhere?
Sure, Your Honor. And, you know, what they try to present is sort of a black and white issue on this topic. You know, this is not a black diamond trail. I think how the court should and most reasonably see is actually variability depending on where you are, right? Because the level of skiers and the obviousness of risk or assuming a risk for a skier will depend on where you are on the mountain, right? And so here is a green trail.
Counsel, isn't that kind of the point, though, that, I mean, this wasn't a black diamond trail. I mean, so the risk or the measures that are taken to mitigate the risk have to be commensurate to the risk. And here, we're talking about basically, it was almost level. I mean, so, I mean, how is this, I mean, how would this have even required them to do anything, given the nature of the terrain?
Yes, Your Honor. So one key point is actually the obviousness of the danger, right? We have testimony from my client and my client's friend, Mr. Scythe, who has skied on this mountain many times, and we don't dispute they've skied on this trail before, but the level of danger is not apparent from the slope, when you're actually skiing on the trail, okay? And what the court can see is if you actually take a different angle, how steep the drop-off is, and actually my client suffered this injury. So here is an issue of you have a green beginner trail, and at least without the fence, it's not an obvious danger, at least the degree of it. Even if you've skied by there a number of times before, still that the degree of the drop-off is not clear to people, and that is on the record. So I think that's a key distinguishing factor here. And
So every time there's a steep drop-off somewhere, a skier is gonna have to put up a fence to keep people from going off of it.
I don't believe the court needs to find in our favor every single time. I don't think that, for example, right, on a double black diamond, right, or this can be.
Wouldn't there be more hazards on a double black diamond? I mean, my experience is on cat tracks, there's, they're flat and there's not downed trees and underbrush and, but that frequently occurs on double black diamonds, so we don't have to protect against those?
I mean, not necessarily, because I think a skier assumes a different risk on higher degree of difficulty trails, Your Honor. So that's what we have here. And frankly, on more of a green diamond trail, a skier might have a false sense of security right there because they're not anticipating such difficult terrain.
The level of risk dependent on the competency of the skier? I mean, you focus on beginners, but if you have highly competent skiers, as your client indicates he is, this should be less of a risk for him.
I mean, they can make that argument, but I don't think, ultimately he's held to a reasonable person, right? As courts have held in lots of different situations, that he shouldn't necessarily be prejudiced by, having a higher degree of skill, right? And so he still needs to be held to a reasonable person. And honestly, this is going into a comparative negligence argument as well, Your Honor, which we can see will at least be a trial issue here, right? And that's one of the things that is important to understand, is that this is depriving my client of a trial, right, here on the issue of reasonable care. We have some persuasive authorities by federal courts since Meade, which is the last time the court has really addressed this type of case. Meyer, which I concede is not a reported decision, but it discussed whether a particular measure employed by a ski area would have prevented the injury is an issue for the jury, right? And so we contend here, this is plainly a jury issue. We have expert testimony from Mr. Gale, who is our client's expert, who talks about how these measures are readily employed in these type of areas to at least stop or decrease the speed of skiers, right? And
So I want to go back to the duty that your client would, or that the appellee would owe. If, let's say we assume hypothetically that your client, or they had a duty to warn people about this because it's an area where it's assumed to be safe. But in this case, your client testified that he knew about the danger there. So the question of warning seems to be kind of missing the point. He knew there was a danger there. He skied that 100 times or whatever it was, and he knew there was a drop-off. So now we're into the issue of not the duty to warn, but the duty to catch him, and that seems to be raising, and back to Justice Gustafson's question, a higher level of action by a ski resort.
yeah, and Your Honor, I think, they pointed some of my client's testimony at the end of his deposition too. He also said he didn't understand really the degree of the danger. I think he'll concede that if he falls and it's an unknown area, he could presumably be injured. I don't think I don't think that there should be a black and white rule regarding this, and that's one reason why it should be an issue for the jury. Importantly, if they do maintain a fence there, okay? There's industry standards about maintaining a fence. That's on the record before the court. On top of that, we at least have a reasonable jury could actually find, because we have the issue of the groomer. My client testified it looked like a groomer had knocked over the fence. They actually marked that the groomer had plowed that morning and then crossed it out, right? Which I think a reasonable jury could find that a groomer was actually in the area. My client's the only one who witnessed the actual fall and the nature of the fence at the time, right? And I think the court should have at least have some pause about if they maintain a fence in the area and a groomer knocks it over and then my client comes in the area and falls down the embankment, whether or not that's a jury issue to decide. And again, this is the first argument. The second one, which I think we're already talking about, some of the points here is if there was a fence up, right? We have stuff about whether or not there's a better fence to employ, which is effectively bee netting. The defendant put that up, or WSI put that up after my client's injury. It would be more effective at slowing or stopping a skier, right? And here they talk about feasibility, essentially. So it is admissible because, you know, and they don't contend the admissibility of the subsequent measure. Essentially, we have, again, Mr. Gale talking about industry standard of care about this, right? And how ski areas, just in general, in places like this specifically, right? On mountain, or in resorts and these type of trail situations, near a parking lot, green level with a acute specific hazard, right? Because we'll concede not every single green trail has a hazard present every single place, but this is where there's condos right there. He's about 100 yards from the parking lot, right? It's a green trail, hazard's not as clear, and it's a very steep drop-off. If you look at the brief in the photo that I have there, it shows how steep that drop-off is, which really is not apparent because there's sort of trees, you know, you're at a decline of how steep that is, right? And the nature of my client's injuries speaks for itself. Going back into the issue of duty two, this court has held like the greater the degree of danger, the greater the duty, right? I mean, there is a great degree of danger here, and so that speaks to the issue of duty, and what this court is also, sorry.
Somehow. So the greater degree of danger, but is some of the degree of danger, I mean, isn't it tied to how many accidents happen in some spot? I mean, you can say there's a huge degree of danger for this, but nobody ever crashes there and never goes off, and we've never seen an accident. Would there really be, you know, that degree of danger that you're talking about merely because there's a drop-off somewhere, but nobody ever goes off of it?
Well, one, I think that argument only really applies to our second scenario with if the fence was actually up, right? Because if the fence is actually up every day except for the day my client fell down, right, well, then that would be a distinguishing fact from other days.
What I'm trying to figure out is, you know, okay, I might gratuitously put up a fence somewhere to guide people, to tell them, I don't want you to ski over here, I want you to go this direction, right? But you don't really think there's a hazard, like people are going to drop off the edge and hurt themselves because you've never, ever had an accident and you've had millions of skiers come by, or years and years and years where nothing has happened. I mean, every now and then people hit a tree, right? But we don't single out one tree and put a fence around that because there's, you know, if they kept hitting the same tree, I could get on board with you and go, oh my, this is a problem and we knew about it. But I'm just trying to figure out, how does a ski area figure out which obstacle they have to protect you from? And how they would know that in advance, other than just sort of like I go out and I look around and guess.
Well, here, Your Honor, I mean, the ski area, this is their business. This ski area has a risk management team. They're a relatively sophisticated business. And
When you talk about the risk management, I mean, you can't talk about the standard of care like Mr. Gale did, or you can't talk about risk management without viewing it within the context of the Skier Responsibility Act. I mean, going off a drop-off and striking, whether it's a fence or whether it's a rock like occurred here, is defined as an inherent danger by the Skier Responsibility Act. I mean, what happened here kind of seems like it's textbook You know, I mean, that's why we have, I mean, and that's an assumption of risk statute, that if you go out skiing, you're accepting responsibility for any injuries that occur resulting from the inherent dangers of skiing. I mean, there's a different level of responsibility for somebody who's, you know, skiing versus somebody who's just, you know, standing around. I mean, this is an inherent danger, isn't it?
But, Your Honor, I think the point that this court has made before is, despite, you know, the statute's language and the fact that, you know, skiing does involve inherent risk, that does not absolve WSI or ski areas of their duty of reasonable care, period.
No, I'm not saying it absolves them, but I mean, it does have to be part of the equation when you're talking about risk management. You know, at the end of the day, I mean, they're a business and they're looking at managing risk based on what they know is the risk that is shared or assumed by the skiers themselves. So we're not talking about absolution, we're just talking about basically, I guess, mitigation.
Sure, Your Honor, and, you know, I think we've established at least a factual issue of, you know, or a question for the jury to understand is whether or not, you know, they maintain fencing, they maintain safety measures, right? If you go to any ski area, it's not like they don't employ anything, and I think the court would maybe have paused that they don't have any duties ever to employ any warning or whatever. Actually, that would be contrary to the plain language of the statute. So I think what's presented with the court is, where's that line,
Well, no,
right?
but I think that goes back to what Justice Gustafson was asking, which is there have been millions of skiers who have gone down here over the years, had gone by this very place, and this was the first time anybody had gone over the edge. So there has to be, it seems to me, some sort of notice. I mean, this is kind of like her hypothetical, everybody hitting the same tree. Nobody hit this tree before your client.
But we're also not talking about a tree where they never marked, right? They have marked it here, right? So they do, in terms of foreseeability, they're aware of the danger, right? And they've acknowledged that just by the measure that they're supposed to employ every day, right? And again,
Doesn't that kind of then discourage ski operations from marking dangers? If you're saying, I mean, you're saying that they acknowledge the danger by virtue of marking it in the first place. So if they had never marked it and there had never been an accident, then they wouldn't be on the hook? That seems to me like you're discouraging them from taking safety measures.
No, what I think a ski area operator should do, and I think is a reasonable argument on our behalf, is they have to analyze their terrain when they open it to the public and charge people a fee, right? And they made their own independent judgment that this actually was a dangerous spot, right, which might not be apparent or posed a danger to skiers. So I'm not saying that anytime the court has to see it in light of that context, right? They admit that this was a particularly dangerous area, right, and they have marked it. So, and that's sort of evidence, at least to what a reasonable person could see as, you know, a danger. And again, I just want to point to the scenario based on my client's testimony, right, that the fence was down, right? So I think here with the prior accidents, if the fence is down and they actually knocked it down or they didn't check it that morning, right, that a jury could find that to be a breach of reasonable care that caused injury to my client. I understand that he caught an edge, right, and lost control, but then that's an issue of comparative negligence for the jury to decide as well, right? Again, this is all in light of a summary judgment issue, right, and whether or not he can get a jury trial on his case.
So is your position, is your argument basically that despite the Montana Skier Responsibility Act, the ski resort continues to have a duty of care, that they did put a fence up there that suggests maybe they had some reason, and that it's a fact-laden question that's not subject to disposition by summary judgment and should be given to the jury because the reason for the fence is something that needs to be ferreted out?
Yes, Your Honor. Couldn't have stated it better myself. I mean, that's the argument in a nutshell. I mean, recently, the Idaho Supreme Court dealt with at least a ski area liability case, the Mullee case, which essentially points to the fact that, you know, about that it reversed summary judgment, right? Because there was declaration from a ski area safety expert, or ski area expert, just like we have, that, you know, it wasn't a fence, it was about snowmaking equipment, and it shouldn't have been placed in that specific spot. Bam, summary judgment reversed, right? And I think we clearly have that here, where you can have a battle of experts. They have their own ski area expert as well on what is a reasonable measure for them to employ, right? And that's an issue for the jury to decide.
Do you have the citation of that case?
It is, so it's kind of funky how they have it because there's a rehearing, but it's just a Westlaw right now. It's
Right.
2023 WL 8722470.
And Counsel, I haven't read that decision, but it would seem like the placement of a snowmaking machine is different from going off a cliff that's all around and a natural occurrence in a ski area. I mean, it's kind of an affirmative act. That needs to be done with reasonable care.
Yeah, and what we're talking about is the placement of a fence. We have, again, from Mr. Gale, that this is actually industry standard. They claim it's only directional. It's purely just to alert people, there's a danger, don't go this way. It's impossible to stop people, right, definitively. We don't contend that we have to prove that they need to employ a fence that would stop all skiers at all times. But this is a slow ski area. Mr. Mullee testified he was skiing slowly. And so here, we're just saying that there needs to be a fence there that could decelerate or stop, right, a slow-moving skier like my client on that day, right, from falling down the embankment. We have there, and I think that's what's akin to the Millis case, or Millis, I guess is how I'm pronouncing it for the purposes today. That the Idaho Supreme Court said that type of expert testimony alone is enough to reverse summary judgment. That's an issue for the jury to decide. I think here we're engaging in a colloquy about what is reasonable for WSI to do. And I understand to a certain extent the court has, or the court does have, you know, can declare legal duties, black line legal duties, but I don't think here the court can say that there is absolutely no duty at all regarding fencing, period, right?
So can you navigate the path you want the court to take between the MSRA and the common law reasonable duty of care? I mean, so because we've got to get that fence up as a requirement of duty before we get to the jury, which is what the district court found wasn't there.
Yeah, I think at the end of the day, the court has already decided that the reasonable duty of care still applies, despite the MSRA.
But tell me what it is. Define that duty in this context. What gives rise to that duty here that hasn't been taken away by the MSRA?
Well, here, you know, at least under the first argument, is there's a duty to make sure that fence is up in the morning, right? That your groomer doesn't run over it and knock it down, right? Per your practices, per industry standards, right? Which would alert or at least decelerate Mr. Mullee from falling down the embankment and suffering a severe injury.
So you would create a duty on the basis of practice.
Well, I think that begs an interesting question about what does the court, you know, because the court is vested with this power, right? What do you interpret or what do you take from, you know, maybe it's personal experience or common sense in declaring duty? And we're saying that these industry standards, which are on the record, the courts should consider and has been considered by other courts in declaring duty, at least with ski area liability cases.
In this case, the duty, it seems like what you're arguing based on the facts and what you contend are disputed facts is not that the court should impose a duty to erect fences in ski areas, but that here the court should recognize that WSI's recognition that this area needed a fence imposed the duty to properly maintain that fence that it already had recognized and placed. In other words, limited to the circumstances here and not some general duty of care to erect fencing in certain places.
I think there's both. So one is, yeah, maintain the fence that they've already decided to erect because they know it's a hazard. And then second, you know, at least in certain areas, right, per industry standard, like a green run, where there is a specific known hazard by the resort that may not be, which is also determined is not necessarily apparent, right, to skiers, which is, they say it's directional to alert skiers of this hazard, right? So they acknowledge that that situation would be in effect here to employ a fence, an effective fence to decelerate or stop a slow-moving skier, or at least the speed, right, that they anticipate here, which would be slow-moving skiers in this specific area, right? This is not a spot where people are going full hog or whatever down a mountain. They acknowledge, and sure, people can disregard, you know, the speed limit in a given area, but they acknowledge, which is on the record, that typically people will be moving slow in this area. That's what they anticipate. And Mr. Mullee testified that he was in fact moving slow in the specific area. So, so that's our second contention on duty.
So, is whether there was a known hazard, do you think that is a jury question, or you think we've already got enough in the undisputed facts of this case that it was a known hazard?
I believe they acknowledge it was a known hazard, but I think sometimes the degree of knowledge can be a factual issue, right? And jury weighing on whether or not, right, reasonable care was followed here in the specific circumstance.
You're almost at 10 minutes, but I want to briefly, just on your second point, why was it improper for the court to not allow your experts to present that evidence? Because the view seems to be that it was a cursory medical opinion. Do you want to briefly just cover that before you sit down?
Are you talking about on the summary judgment on damages, Your Honor, or?
Yeah,
Okay.
because if you can't prove your damages, then this doesn't matter.
Yeah, so, but you want me to talk about the damages summary judgment?
I just want specifically your issue with the preclusion of your medical expert.
Okay, so it's undisputed. We put on evidence at summary judgment, right? Under Rule 56 is proper. It also includes disclosures on file in the express thing of language of the rule. And, you know, we may have a burden to prove damages at trial, sure, but at summary judgment, we've met our burden, and there is nothing in response there from the defendants. This also ties into, and the court didn't actually rule on some of the arguments they talked about regarding affidavits and whatnot. And importantly, with Dr. Donaldson, I think that actually is probably the clearest error here with precluding her. The court has already found time and time again that nitpicking expert's report, her report said reasonable degree of medical certainty. And then what the court does is nitpick the language in her report. Defendant didn't depose her, right? We reasserted it through an affidavit that, yes, he will require these future procedures. And essentially, she is, the district court is denying Mr. Mullee of a very valuable damage claim, right? And the 6 figures on his future treatment based on this sort of nitpicking of the report. It's Beeler. All the cases are cited that doctors are not lawyers. And so it's in the report. It's an extreme sanction under Hendrickson. They have no prejudice. They just decided not to depose her. I think the Montana Supreme Court case law on this issue is pretty clear cut that that was an abuse of discretion. And at least since we're getting into this argument, I think that's particularly telling in light of how the court handled my motion on Dr. Scheer, where essentially we don't have a pinned opinion. I acknowledge, right, it's not necessarily required here under Supreme Court precedent that he has to pin his own separate opinion, but I was given essentially no information on his opinions that would allow me to cross-examine him on his scientific methods at his deposition. He had a site visit, he made calculations. Think of the Dober challenge, which is adopted on scientific methodology. I don't even know what methodology he used to raise a Dober challenge on how he provided his biomechanical analysis. And we're getting close on time, and I would like a little bit for rebuttal.
Yeah, let's save the rest of the time. Appreciate that. I took you off track a little bit, but thank you.
Okay. And just briefly, I just want to say, comparing those 2 rulings is a clear abuse of discretion as well. I think it actually heightens the court's ruling on the Donaldson issue that they're allowed to present Dr. Scheer with that deficient disclosure, yet I can't present a damages case where they really knew what her opinions was. Thank you.
Good morning. May it please the court, Michael Moore here on behalf of Whitefish Mountain Resort. The question of legal duty grows from the root of law determining the responsibilities of one person to another. So in the area of tort law, which brings us in this courtroom today, it is the very first question that must be answered. And I just heard an argument that lasted several minutes about the facts of the case. Those are the arguments you make to a jury when there are disputed facts, and there are disputed facts here. The question of duty, however, does not hang up on disputed facts, except in very rare cases. There is a stack of cases to the ceiling from this court where the court has resolved the question of duty without having to resolve disputed factual questions. And most recently, Justice McKinnon, you'll recall in the Bassett versus LaMantia case, you commented on this at paragraph 8 and made the point that the fact that there are some disputed facts in the case, and there are certainly those in this case, does not bar this court from resolving the fundamental question of duty. And I want to start this morning by pointing out that the facts argued by counsel on behalf of Mr. Mullee do not bar this court from resolving the question of duty. Now, he wants to convert the duty, I think Justice Baker put her finger on it a moment ago, by suggesting that WSI created its own duty when it chose to put a directional fence, and I use the word directional, to advise skiers leaving the tunnel that the trail bent off to the right. He wants to say that the placement of that fence in that one location on this mountain defines the duty. And now it's up to the jury to decide whether they did that the right way.
So
Right.
did
Yes, sir.
it create its own duty, or did it recognize its duty to put the fence there?
Neither, Your Honor.
I was going with the hypothetical. Well, go ahead.
Okay.
Tell me why.
All right. So duty, it does not hinge on that individual action. And furthermore, in this particular case, we have to be very specific about it, and I'll explain why in a minute. We aren't talking about the beginner skier who's coming through this tunnel for the very first time and leaves the trail and ends up in the stream bed. We're talking about Mark Mullee, who grew up on Big Mountain, literally. He spent 4 decades skiing there. Now, the records we have show he passed through this area at least 100 times that season, and 10 times in the 10 days or 6 times, whatever it is, a lot of times, 2 times in the 2 days before. He had been there. He knows what's there. So there's nothing about this fence that.
Wait, you're talking about the
Yes,
facts.
pardon me.
You're talking about the facts now instead of the legal
Sure.
duty.
I'm
And
answering the Chief Justice's question, Justice Baker, and the point I'm making is they don't inform this court about the duty. The question of duty is a more fundamental question here, and this court has for decades addressed that question first. And fundamentally, it's an essential question of whether the plaintiff's interests are entitled to protection against the defendant's conduct, right? And in this case, stated another way, the question of legal duty is whether Whitefish Mountain Resort may be required to answer in damages for Mr. Mullee traveling out of control off this ski trail into a stream bed. It's a question of law for the court, and the district court handled it correctly, as this court has done in so many cases. And the question of duty has two elements in the analysis. The first element, and I will admit, I've read the court's cases, sometimes these get put in different order. But the first element, I think, is foreseeability. And the court has described it most recently in that Maryland casualty case as follows. The harm at issue, the issue of foreseeability, first question, is the harm at issue of the type reasonably foreseeable under the circumstances? And if we get there, then the court goes further and asks the question, if so, if it's foreseeable, would the imposition of a duty and liability comport with public policy under those circumstances? And so let's talk about the real duty here and the way this court resolves that question. Everybody knows, because we've read Meade and we've read the statute, the Montana Skier Responsibility Act, that as a general proposition, a ski area operator owes a duty of reasonable care to skiers. Not very helpful in this particular case. So we have to look at the law as a whole. And here we have the Skier Responsibility Act. We don't have the luxury of counsel here arguing duty as if the Skier Responsibility Act did not exist, because it does. In fact, it was enacted 47 years ago. It had a rough first 10 years, to be fair. But since it was amended, and since the Meade decision, which was 31 years ago, it has been the law of the land. And when you read the Montana Skier Responsibility Act, you will see it requires operators to act with due care, but it's clear what the act is saying. That is that operators are to educate and inform skiers of the inherent risks of the sport. And it holds skiers responsible for their own actions. Now, I understand that's a gross summary, but it's very important on the first question of duty, which is foreseeability. Because what the act tells us—
Doesn't the fact that the fence was put up tie into the foreseeability and somehow create an acknowledgement that there was some sort of a duty? And isn't it a question of fact on whether the purpose of the fence was to mark direction or to protect against falling into the stream?
Justice Bittigary, I respectfully disagree, because whether or not WSI has a duty has no relationship to the fence, and I'm getting there. But no, the conduct of the ski area in placing the fence, while Mr. Mullee's theory of liability debates the purpose, the law does not require the placement of a fence.
But once the fence is there, doesn't that change the complexion of the issue?
Only in the case, which isn't this one, perhaps, and I'd have to hear all the facts, where—
Is that because this is a fact-laden issue that really isn't amenable to summary judgment?
Again, I respectfully disagree, because the issue of duty can be resolved on the statute and on the two-element test the court has repeatedly implied. And the presence or absence of the fence does not control. And particularly here, if we want to talk about the disputed facts, not the ones that are in dispute, we have it undisputed that an extraordinarily experienced skier who knew this area as well as anywhere on the mountain passed through an area that millions of skier visits later, and many years later, not a single other reported accident in this location. And his request is not for the placement of a fence, Justice Bittigary. His duty, the duty he admitted on the record in the argument in the district court, and that the district court correctly characterized, the duty he wants is this duty: the duty to catch him, to arrest his motion once he has admittedly breached his duties of care in losing control and traveling off the run. So this is a very specific duty he's seeking. And this is the very specific duty ruled upon by the district court. And and the presence or absence of offense has no bearing on Mr. Mullee's circumstances. He knew what was there. And the whole degree of harm, let me just address that quickly, and I
Before you do-
apologize.
Before you do that, Mr. Moore, can
Yes.
you were going to give an example of when the placement of a fence would create a duty? I guess I'd like to hear that.
It could.
I'm imagining one scenario, and I wonder if it's the same.
And this is hypothetically speaking. We'd all have to hear all the facts in order to know whether this would create a duty in the environment I'm addressing, which is with the Skier Responsibility Act. So understand, I'm not conceding that point. But I thought about it. And what I thought about was, well, if you were in a particular area of the mountain, let's say a super high traffic area, and something about the way you had done it for a long enough period of time allowed people to rely on you, right? They came to believe that it would actually do something to keep them on the ski run, nudge them in the proper direction or something like that, where there was evidence that for years and a reasonable period of time that the presence of a particular safety measure, whether it's a rope, Justice Gustafson talked about that, or a fence or some other element, where there was actually reasonable reliance that somehow that would protect you from yourself, in effect, then maybe we're getting closer to a duty. But my argument here is even then, it would not do so for this reason. And this is the recognition that has to be made on the issue of foreseeability, and also on the second element, whether public policy supports a duty. So my answer is, I might be able to come up with a scenario where the placement of some kind of barrier or fence could in the right case, but this is not that one, for this reason. The Skier Responsibility Act is not just an act put on the books because everybody likes ski areas. It is an act that recognizes through common sense the reality of operating a voluntary recreational activity on a mountain. There are literally, people use innumerable too often, but here it applies. There are innumerable risks, and they cannot all be mitigated. They can't be made to go away.
But isn't that actually the conundrum? You don't want them to go away. That's the attractiveness of a downhill ski resort, is you want some danger. If everybody had the same flat ski run, you'd have no customers.
That's precisely right.
So that's what I'm struggling with, is if we're beyond the statute.
Unless you had a lot of powder.
Yeah, that's true. Now, my ski experience is a smidgen compared to hers, so I'm going to defer to her on this. But the issue I have is if you go beyond the statute, you're acknowledging there is some extra statutory common law duty of care. Question is, how do we define that? That's really, obviously, that's what we're all grappling with. And because I would say, I agree with Justice Mitigary. If you've got a fence there and it's been there for 20 years and it's prevented a bunch of accidents, maybe that was a foreseeable hazard that you warned or whatever. But then you go to the second part, which is public policy and how that defines that duty. That's where I'm stuck.
Well, I see a difference between putting up a fence to protect from going over the cliff and the question of whether there's reasonable care. My scenario I was thinking of, and I want you to answer the chief's question, but my scenario I was thinking of is if you put up a fence, you have to exercise reasonable care in putting up the fence. In other words, you can't put the fence up in the middle of a downhill run, and that's not exercising reasonable care. So you have a duty there. I'm not sure I get to the duty in the other scenario, so.
Okay. Well, there I think it's two questions. And one you're really talking about, and that there's a very long opinion from this court in that Maryland casualty case about the volunteer doctrine and how that applies and when it applies. Well, that applies to third parties. We don't have a third party here. we have the ski area operator and the skier, the two parties who are specifically defined by the Montana Skier Responsibility Act. And the act, if you boil it down, and I've been reading it for a lot of years, it comes down to this. It essentially says everything is foreseeable, so nothing is foreseeable. Now, if you take that strict line, then it's unconstitutional. There has to be some measure of care applied. And so how do you do that? This is what you're struggling with, I believe, and that everybody on the bench is struggling with. And here's how you do it. Here's my suggestion. There is a duty of reasonable care, but it must be informed by the realities of the environment of this recreational activity. And even more importantly for this court, it has to be informed by a piece of legislation that has been on the books for 47 years.
So on that, I've been attempting to write out a duty statement that would encapsulate the plaintiff's arguments. The district court kind of referenced parts of it, but I'm on my 6th or 7th draft. I'll read it to you, and I'll also let plaintiff's counsel take a shot at it too, but it seems to me this is the duty statement that the plaintiff is asking for. A ski hill operator has a reasonable duty of care to protect the skier who loses control and departs the designated trail at a place where it is foreseeably dangerous to do so. Now, do you think that encapsulates the plaintiff's claim?
I do, Your Honor. I have a slightly different version. Here it is. Was it and this is really addressing the foreseeability element, because once you get into the public policy element, I think the analysis is even clearer, but bear with me. Did Whitefish Mountain Resort have the duty to catch Mr. Mullee, who, because of his own conduct, lost control and traveled off the ski trail?
At a place where it's foreseeably dangerous?
Sure. And this whole analysis of one risk is greater than the other, I defy you to go up to Whitefish Mountain Resort or Bridger Bowl or any other mountain and stand on the edge of a run every 20 feet if you want and get two people to agree on whether this risk is greater than that one.
Do you see that the foreseeability, though, has any relationship to, like, number of accidents? I mean, because it does seem to me that, you know, if you have one particular tree that 100 people hit, the ski area should have an obligation to not only put up something that just, I mean, more than just tree, right, sign, but they really need, like, from lift towers, right? We know they're bigger hazards. We put padding on them. We do all sorts of more things. And so, I mean, I think there's so many obstacles in a ski area that you can't pinpoint one. But I think there is some obligation in foreseeability that if you really know people are doing this regularly and being hurt and injured, then you have to take some step, and it may be more than a rope. It may be a fence. It may be two fences. It may be closing it off. I mean, do you think that that has anything to do with foreseeability?
I do. I believe that, so my suggestion to the court is that the foreseeability analysis, which you're not going to change and you shouldn't, it's the proper element of determining a duty, has to be seen through the lens of the Skier Responsibility Act. And Justice Gustafson, you just made the point for why that's true. There are so many risks and they're so variable that you can't just say, well, it's this one today and it's that one tomorrow, because that's what it will be, folks. It will be a retrospective analysis, just like this case, where they say, oh, you should have put something up there now that we know somebody got hurt. That's why it's so relevant, and why here, and particularly with this plaintiff, there can't be a duty to catch him.
Every time you say particularly with this plaintiff, seems to me you're getting into facts. And I mean, and that's the thing is, I mean, I'll be the first one to say, I think the plaintiff, if this were to go to trial, has a real tough road to hoe. But isn't that kind of, I mean, the Skier Responsibility Act at its core is basically an assumption of risk statute. skier shall assume the risks of dangers that are inherent to skiing. But he does have an expert who said that this is the standard of care for ski operations. And, I mean, doesn't that kind of at least give him the shot to say to a jury, and they may be incredulous about it, but gives him that shot to say, make that case to the jury?
Justice Shea, again, I would say no for this reason. And to her credit, Judge Eddy understood this. She said, if you let the experts tell you whether there should be a duty of care, then there's a duty of care in every case. And the other thing that happens, because that's what they're going to say, right? They're going to say that in every case. So the other problem with that is, and I don't mean to be harsh about it, but it's an abdication. This court has the responsibility, and you're the final word, to say what the duty of care is. It's not a hired expert who in every case will find a reason to explain why there's a duty of care. Instead, this court has to apply the common law and the statute through the lens of the Skier Responsibility Act to decide whether, with all these innumerable risks on the facts of this case, is there a duty? If you listen to the experts, there's a duty in every case.
So
What
let me
you're
just
talking about-
ask you, I'm sorry.
Go ahead.
Go ahead and finish.
What you're talking, I mean, really goes to the second part you were talking about, the public policy
Yes.
argument.
It does. It
Right,
does.
before you
Justice
run out
Baker.
of time, there are federal courts who have looked at this question also, and let me just read you what they have said the duty is, because I want to ask if you agree with it. These comes from Judge Malloy's opinion in Waschel, quoting Judge Christensen and Kopiakin. In the case of naturally occurring inherent dangers, providing general warnings of unmarked hazards may be sufficient so long as the foreseeability of harm from the specific hazard in question is apparent to the skier. However, a ski area operator violates its duty of reasonable care if it has the ability to eliminate a risk through specific warnings or otherwise and fails to do so. Is that those two sentences a correct statement of law?
No, Your Honor.
So explain.
And that was quoting Judge Christensen.
Well, Judge Christensen, yeah, well, I happen to know Judge Christensen, and here's what he said. He said, a ski area operator cannot be expected to expend all of its resources making every hazard or potential hazard safe, assuming such an end is even possible or desirable. So my answer to your question, Justice Baker, is that was the Veschlik case. I defended that case too. And that was a young man who went into a tree well at the top of Whitefish Mountain Resort, and he expired. And what Judge Malloy actually ruled was that the Skier Responsibility Act did not apply to that accident. So that case, now he gave me 28 U.S.C. 1292B appeal to the Ninth Circuit. The case resolved, we never went there. But Judge Malloy's ruling on the facts was that the Skier Responsibility Act did not apply. So his discussion there does not take into account my argument here that you must analyze the duty within the lens of the Skier Responsibility Act.
So, same case as we're dealing with today. The plaintiff is a 7-year-old child who just finished beginner ski lessons, and this is the first time down the mountain to go to the lodge and have some hot cocoa. Does the answer change as to the duty at that location?
If it's the first time for a skier going off, no, it doesn't change. There's still no duty, because if there's a duty there in that circumstance, then there's a duty everywhere on the mountain. And now we've just essentially made ski area operators guarantors of the safety of skiers.
But is there a different danger and duty at that location, which is supposedly safe location beginner, basically at the, at the bottom, versus the double black diamond where people want to jump off a cliff?
Well, I thought about this very hypothetical, so thank you. Here's my response. If you have the most challenging run on the mountain, now you mix it with the least experienced skier.
Right.
And you ask me the same question. And you say, well, you've got the most challenging run on the mountain and the least experienced skier. Don't you think you should do something about that? So I don't care which point you pick on the mountain, we end up in the same analysis. How is it we are, as operators, ski area operators, supposed to prevent against these risks when they are everywhere? And our clientele is as varied as you just described them. And the circumstances that they embrace these particular risks is unlimited. That's why we have a Skier Responsibility Act.
I'm not a skier, but I would imagine that there aren't fences along all of the different trails that people can ski, and that this particular spot was selected for a fence. So that's where I get hung up, is why was there a fence there then? And why does that not create some sort of a factual dispute?
I understand your concern, and if there was a duty to have a fence, that is a debate I would love to have in front of a jury. My argument is there's no duty to have any fence in this location, because this is one of innumerable hazards on the mountain, fully recognized by the legislature in as clear a public policy statement as you're ever going to get to the second part of this analysis, that we are not going to hold ski area operators responsible for the inherent risks of this activity. And let's keep a couple of other contextual issues in mind, folks, and that is, this is a voluntary activity. This is not driving the highways of the state. This is not other things that are essential to our daily functioning. This is a voluntary activity. People choose to do it, and now they pay a lot of money to do it.
So here's what we're left with now. We're left with, let's say we say this case, there is a duty beyond the statute. This case doesn't implicate it, and we move on. Or we say, here's what that duty is an answer, probably completion to the question from Justice Rice. What's your answer to his question as to what is the definition of that common law duty beyond the statute?
My answer, Chief Justice, is this. It doesn't have to be any more defined. All this court is resolving in this case is whether there was or was not a duty. It doesn't have to define the duty for future cases. And in keeping with the way the court does business, that would not be uncommon to not stretch to the next set of facts. And so what you would say is there was no duty in January of 2019 to catch a very experienced skier who lost control and went off this trail. And that's the end of our analysis. And in the next case, you'll resolve. Now, in many cases, it's going to be simple. But in this case, it's not. But you don't have to define the duty. This is not like Justice McKinnon in this other case where she is trying to actually define the duty in response to a certified question from the Ninth Circuit. You're not being asked to define the duty, except to the extent of deciding whether there is one to this plaintiff in this case.
But every skier loses control at some point.
Absolutely.
So the question is why that's such an important factor here when you'd have to assume that accident was going to be, but it could have been intentional, in which case they've clearly taken the risk upon themselves. But that's why you've repeated that several times when questioning that issue, because every skier loses control at some point.
That's right, and that's a recognition in the statute that that's a reality of conducting yourself in this environment and engaging in this sport.
So you're basically advocating for us to do a memo opinion. I mean, I don't, I'm not trying to speak, but you really want us to not really look at the bigger picture of, how ski areas might use this case to inform themselves. You're advocating that we do it very, very narrowly.
I am, because every circumstance is going to be so unique. We've talked about several hypotheticals in this setting. I think you're illustrating just how unique it is in that environment to decide whether or not there's a duty of care. And so, yes, I am saying this deserves a narrow resolution for that reason. Broad proclamations are probably going to result in more confusion in the district courts, more appeals, et cetera.
So that, even though duty is a question of law, it does depend on foreseeability in the circumstances of the case.
It does, absolutely. This court's made that absolutely clear. And that's why the specific facts of this case are the controlling factors, and I just got buzzed.
Does anyone have any further questions for Mr. Moore before he sits down? All
Okay,
right, thank you, counsel.
thank you.
We're ready for rebuttal.
Okay.
Counsel, as you start, I'm sure you're going to get to duty. Mr. Moore says, well, we don't need to articulate a duty. We just need to say there's not a duty here. Of course, that is if we're going to hold for the defendant. But if we're going to hold for the plaintiff, I think we would need to articulate what the duty statement is. And I'm hoping within your argument, if not now, you will tell us what statement of duty you're asking the court to adopt.
Yes, Your Honor. How we see it is that a ski area operator has duty of reasonable care, and in this case, employ a reasonable safety device, whether it's warnings or fencing, right? We all know that they don't dispute that they use fencing as part of their business and in the specific spot. So reasonable fencing in an area of known danger, right? And what was discussed was the Waschel, he pronounced it correctly, but it's a German name because it's a German foreign exchange student, where it was articulated, right? A ski area operator may violate its duty of reasonable care if it has the ability to eliminate a risk through specific warnings or otherwise and fails to do so. So that's what I believe is the appropriate standard, Your Honor, and would be a reasonable scope of duty for the court, not some specific. And what I think Mr. Moore is trying to have the court do is present a very narrow holding under the circumstances of this case, where every case we don't know what duty is, and we'll see what the trial court decides, and maybe you'll have to go up to the Supreme Court to find another narrow circumstance on duty depending on the facts of the case. And I think what the court just heard is a whole lot of discussion about the facts, right? And I think the court here has incentive to provide more elaboration on duty, right, beyond just a warning device, right? And what the courts have held is it's not limited just to warning about just go in a different direction, a sign. That is not what precedent provides. And so I'm starting to ramble a little bit, but I believe it's just a reasonable device, warning, fencing, right, per industry standards. We have that here. They haven't really attacked Mr. Gale's opinions about using fencing in this type of area to decelerate or stop skiers, right? And again, about the dangers, I think the important point is this is not a double black diamond, right? And I think when a skier signs up for or decides to go down a particular route, I think they are assuming certain risks there, but that's not what's assumed here on a green run. You know, children, handicapped people, right, go down it, right next to a parking lot, right next to these condos, right, where it's essentially more just for children to go through the tunnel and meander through, or just get to your car, right? You're not signing up for this danger in the specific spot as a skier. And again, I think the court already kind of acknowledged this with the questionings with Mr. Moore, and I already stated that. My client, he's held to a standard of a reasonable person, ordinary person, right? And when we get into his actions and losing control, we're getting into more factual, more of a factual thicket and comparative negligence. Does that answer your question?
So Mr. Moore agreed with my point, and I want to know your opinion on it, that if you want to shut down all the risks in a ski hill, you just shut the ski hill down. That kind of the point of the attractiveness of doing it is this element of danger. So that's my concern with your posing of that duty. It seems like it's contrary to the statute if you're asking basically the ski resort to eliminate or mitigate all those known dangers.
Well, and you know, I think that's where we get into what's reasonable care, which defines duty, and what's foreseeable, right? And here, right, again, I don't think you're signing up for that danger here in the specific spot, right? This isn't backcountry skiing, and we're not suing like the U.S. Forest Service or even dealing with a route that, is much more difficult, that presents hazards, and baby skiers don't want these kind of measures in those. They want more of the natural environment. That's not the run here. And when you're on runs like that as a skier, you're informed by that context, Your Honor. And so, again, I think, interpreting it, what the federal courts have done, at least, and at least well-reasoned, written out opinions, well-reasoned, is that ski area operator can violate the duty of reasonable care if it has the ability to eliminate the risk, right, and fails to do so. And so here, again, we have the fence here. They have the measure. They've identified it as a risky spot, right? I think the questioning to Mr. Moore acknowledged that reality. And I think what we have here is where the lawyer is almost disagreeing with his client on what they think is reasonable, because they've already made a determination that putting a fence there and warning their clientele is a reasonable act, and is at least a danger that they need to alert their clientele of. Where Mr. Moore, I believe he argued, is that they don't even have to put a fence up there.
Were the federal cases that you referenced that say that if you have the ability to eliminate the risk and fail to do so, you violated that duty? Were they ones that implicated the Montana Skier Responsibility Act? I mean, is that applicable in those cases or not?
Yeah, so, you have Meyer, which is an unreported federal decision from 2019, and then you have Voschel. Meyer takes Voschel, he says that they found the act didn't apply. Well, if the act didn't apply, I don't see why it wouldn't apply here then, or would apply here.
Because of the tree well, and at the time that skier was injured, the act did not cover tree wells. That's the distinction in that case.
Sure, and still with Meyer, the court took that reasoning and defining duty under the act as well. I don't think the act has specific provision about this fencing issue either.
Well, but the act, it kind of does. I mean, because it talks about inherent dangers, and those are the dangers that are, and I would argue is the statement of public policy, those are the dangers that the skier assumes the risk for. And it does specifically include fences and natural surfaces. And those seem to be the only two things that are implicated here, is whether the fence was down or whether he went through a fence. We've got a fence and we've got a natural surface, and those are inherent dangers.
And I think this now speaks to the broader point made by Mead and Brewer, that the act cannot eliminate the ski area's duty of reasonable care. So I think regardless of the applicability, you still have the duty of reasonable care. Duty of reasonable care by a ski area operator, I think that would apply in either scenario. You have Meyer still taking Voschel. Can I finish my point briefly? And still finding that if there's a foreseeable risk, known danger, and they have the ability to eliminate that, that's a violation of the duty of reasonable care. I believe the record is clear on this point. At least we're entitled to a jury trial, and request that the court remand this case to the district court with instructions for a jury trial and reverse summary judgment. Thank you.
Well, thank you, counsel. Case is submitted. I believe after we exit, I'm going to ask Justice Baker to give us instructions here. After we exit, are we going to do something?
So, well, we're really excited to have all the students here today from the area schools, and we've heard that you might all like to have some questions for us, which we would be delighted to participate in. So we will be leaving the stage here, but some of us will be coming back in shortly, and we'll stand around and probably up here for a while to talk more about the court's processes. We can't tell you what we're going to do in this case, but we can talk to you about how the court operates and questions you have generally about the system. So stand by if you're interested in that, and we'll be back.
Okay. Thank you all for coming. Thank you, MSU, for hosting.
Sorry, he made you commit to a time for rebuttal there. It's getting.
Hard and fast either, so.
I'm still getting used to a new chief. I don't always know how he's going to do
Well, I
things.
think actually he did kind of concede maybe I'll look the bird so.
All's well that ends
Well,
well.
hopefully the opinion doesn't say you screwed up the rebuttal, therefore he loses.
I can't imagine.